good afternoon, everyone. I am Shannon Taylor. I am the Commonwealth attorney, as the term that we like to use in Virginia, and have been the elected in Henrico County since 2012. And one of the things I think that makes all of this, this pandemic so crazy, is that we've all been kind of coming at this from our homes, so to speak. When I say homes, like our home location. When I have talked about the success of how we've been able to maneuver through the pandemic, I refer to the three things that I say are necessary to provide your success, and that's infrastructure, technology, and resources. And it just happened to be in my jurisdiction that we were very blessed to be able to have all three. Our circuit courts were already, our superior court, circuit courts were already going to be undergoing some technology upgrades. So when we were trying to, be able to be be more flexible with the pandemic, the good news is that we were already there and being able to facilitate that change. So we, like everybody else, we're just trying to come up with some good ways to handle the pandemic. And I think everyone can see this intro shot, because who could forget that about the cat video? I'm sure we all felt that way sometimes, but that is what we've been dealing with for 15 months, for those of you who are still not in the courtroom yet. So let's see here. So I'm going to try to use terms that apply to everybody. Because some of these things are different in each state. For example, in Virginia, we are very much a reactionary type state. So we don't have the opportunity to review charges and make decisions as to who's going to come in or who's not going to come in. We have our law enforcement who are doing about 75–80% of the contact with individuals there on the street. And then that's when we have an opportunity to see people. And I'll tell you, we were already in Henrico doing video arraignments. And for those who were being held in jail and had not been given bond, I will tell you that has been a subject of it's been the subject of a lot of discussion, because, and I'll hope we'll be talking more about this in the breakout room, in terms of having representation. If you're a jurisdiction that does not have a public defender's office or does not have a court-appointed counsel who are already there, you're dealing with, the remoteness of not being able to speak to your client, or there's just no one there to speak for them anyway. But we did talk about, the idea, the ease of using video for the judges for that first appearance. Obviously, there's, for arraignment after felony charging, for the jurisdictions that you do have that ability to oversee what cases are coming through, you can see how that's working for you. Again, for us, we have both misdemeanors and felonies in Virginia. Pre-trial conferences, I think depending on the subject matter, you may want to feel whether or not those are appropriate for remote to be able to have those conversations. I think we all agree that if there are things that are easy to talk about, then that's fine. I think one of the things we have realized about Zoom is that when you are trying to have kind of detailed conversations, if you are dealing with kind of minutia aspects, I have found that Zoom was very difficult to maneuver through those things. So the same could be said for non-evidentiary hearings. And then of course, continuances or adjournments of court dates, those could be done remotely, because again, those are things that, if not contested, should be easy to maneuver through. Now, the ones that are more meaty, obviously motions practice, particularly motions to suppress, any type of motions in limine, again, where there's going to be some adversarial proceedings going on. I think some of us feel that those are too important, particularly when we're dealing with any type of constitutional amendments, constitutional rights, that perhaps those are better being done in person because the importance of those matters. And I think too, that when you're when you are anticipating trying to build your record for any appellate issues, again, you're going to want to kind of do that balancing analysis to see what you really should do or not do. Discovery conferences, that's not something that we do a whole lot of in Virginia, but for the states that do discovery conferences, again, I think that's one of those things where you kind of feel out what are the importance of the matters that you're discussing. Non-evidentiary competency matters. For those who have had your doctors testify on Zoom, sometimes if everyone's in agreement, then it's an easy way to handle things. But if you are really wanting to cross-examine your expert, you also want to figure out what exactly is the point you're trying to make, and is that something that should be done on Zoom? Knowing, of course, that some of our experts travel from far away. I had an expert that was coming from Boston all the time to Virginia. And so we tried to do the best we could to accommodate him. Search warrant applications. Again, because we're talking about probable cause, depending on who you're dealing with, in Virginia, we've got a magistrate as well as a judicial review, and our magistrates are not necessarily lawyers. So for your states to figure out how you are having your conversations with your court, and really kind of assessing the person that you're dealing with in terms of that review, if you think that that's doable in your jurisdiction. Sentencing, that was another, I know I've had this conversation. Again, sentencing is really critical for the defendant, for your victim. And sometimes we lose on these Zooms kind of the essence of the person themselves that we're trying to convey. So if you're going to be having people who are going to testify about important things, you may want to, again, assess whether or not that should be done in person. The progress reports for treatment courts, I think that the treatment courts go fairly well, but again, we want to have, if it's going to be the judge talking to the individual, because our treatment courts are geared up because it's so important to have that connection. I'm not so sure about running the courts themselves virtually, but certainly some reports could be done. But you don't want to lose that really important relationship between your bench and your individuals and your treatment courts. Plea bargaining, that is something that, I don't know when we're talking about just having these type of cases being presented to the court. Again, as we've indicated before, the resistance from the defense counsel about whether or not they're able to convey the necessary information to the court is something to consider depending on what your issues are. And then appeals. I have actually, my office does not do appeals. I know that some of the offices out there in the different states do. And again, depending on what your issue is that you're trying to present to whether it's a 3-panel or more judges, the good news is, at least to the appellate work I used to do when I was doing defense work, we know that those judges are very orderly. So we know that there should not be a lot of cross-talking during those hearings. So it may facilitate an appropriate hearing. Now, the out-of-jurisdiction witnesses, the testimony for those individuals, again, trying to determine what is exactly the information, the evidence that you are trying to get from that witness. How critical, how material is that to your case about whether or not you want to have them be as effective as possible? So that's kind of how we all feel now. Just the mute all button, of course, because how we all still don't know how to do mute after 15 months is pretty funny, but that is exactly how we feel like sometimes. So when we talk about who should be in the room when it happens, I love making a Hamilton reference when I can. I think, these are kind of the easy ones. I mean, we did some proceedings early on where the judge was in his chambers, and we were in separate locations, that being the prosecutor and the defendant's counsel. And then we had a defendant, if they were incarcerated, still in the jail. So we had all these setups happening. And we all agreed that at that point, for those individuals who could not be together, we were going to be very limited in the types of hearings we were going to do. So again, we're trying to figure out what is it we're trying to convey to the court, how important, what type of hearing are we talking about? Is it a preliminary hearing? Is it a trial? Is it a bond hearing? And trying to figure out, going back to my three things, infrastructure, technology, and resources, about what you think you're able to handle in your jurisdiction.
Sorry to interrupt, just about 5 minutes left.
Oh, well, this is my last, this is the last one. So electronic filing, I will tell you, this is, again, something that in my state, we're having a lot of conversations about. And so what I think is the most important thing here is that you talk about a filing system that, again, technology, resources, and how well is, like, who's in control of that filing system. For those of you who have done federal work before, the PACER system is something that I think is an excellent model. Now, of course, it costs money to engage in it, but I really liked PACER. I like the idea of filing things, getting my notification when co-counsel or opposing counsel was filing something, and anytime you were getting notification from the court, you knew when it was ready. And I liked that system. In our state, our circuit court clerks are elected. And so because they are elected, they are kind of given this carte blanche to create their own system. I will say that my previous clerk of circuit court did not consult anybody when she came up with her system. So as we're working with our new clerk, we're trying to figure out, what can we do to be helpful to help her create the best system that's possible. But this, in my opinion, electronic filing should be a no-brainer moving forward. Now, of course, the sealing and expungement paperwork, that's something, anything that's under seal, understanding that there might be some documentation that is going to have to be still in hard copy, but you can work with all the parties involved and I think come up with a system that is very, very efficient.